All right. Welcome, everyone, to the Lead Generation World Podcast with my friend Eric Troutman from Troutman Amin. How's it going, Eric?
It's going good, man. How are you doing?
I'm doing pretty good. Before we kick off, I do want to just go over a couple of housekeeping items while everybody starts to join. We're both live on LinkedIn and on YouTube. And for those of you that might miss it, or if you know somebody that's going to miss this live, it will be at these same locations, LinkedIn and YouTube, as a recorded file. So you can just come back here after this is done and it'll be there and you can watch it over. And that goes for missing something as well. But the most important thing about this is that we'd love your participation. You can start to leave questions, comments, whatever it may be, in either YouTube or LinkedIn, and we'll see them, and we'll be able to get those addressed, because I've got certainly a list of questions, but really your questions are usually way better than mine, as many as we can. If you don't know Eric Troutman, he's a partner at Troutman Amin LLP, and he's also got one of the best, or the best, publications on TCPA and call center and call compliance, called TCPAworld.com. And if you don't know, now you know. You got to check that out and go subscribe to his newsletter. He also has a conference coming up, Law Conference of Champions, right, Eric? Give me the date on that.
Boom. July 13th and 14th. The 14th is the big content day. The 13th is a big networking opportunity, pre-gala dinner sort of thing. It's a great time. People are going to love it. So.
And who needs to be there?
Well, I mean, anybody that is trying to comply with the law around marketing, in particular advertising, and that includes, of course, outbound calling. A big piece of the show. It's not just a TCPA show, but a big piece of the show is laws around outbound calling, and lead gen is a big piece of that. But also, data privacy, AI, state level stuff, all of this, plays in. And it's kind of a different format this year, because in past years, it's just been kind of the Troutman Amin lawyers giving presentations. This year, we've got over 20 speakers, panels put together, like real pros. Frankly, I dare say it's going to be a really good lineup of speakers. So looking forward to having as many people there as want to come. We still have some tickets. This thing sells out every year. I predict it will sell out probably by the end of the month, but it's not sold out yet. So come on in.
And then they just go to the Troutman Amin website, or
no, lawconferenceofchampions.com. Okay. I know that's a lot of words. There it is. lawconferenceofchampions.com. This is a sticker. You get a free sticker if you come. You get lots of free stuff if you come. But yeah, visit there. And if you need a discount code, if you're a client, you get a really good discount. If you're a Reach member, you get a good discount, not as big as if you're a client, obviously. And if you're a potential new client, reach out to me. We can talk, and maybe I'll get you a discount.
Okay, perfect. And then that's a good segue, because we also wanted to mention Reach, which, guys, we're going to be talking a lot of information here about the current state of compliance and what's going on. But if you're a Reach member, you're likely already in the know. If you're not a Reach member, this webinar is really, really important to you, because you're not in the know. So you'll want to become a member of Reach if you're not already. And you can just go to reachmbc.com. It's scrolling across the screen to find out more information about that. It's just about being ahead of the curve and understanding what's happening, what's coming. And Eric does a phenomenal job orchestrating the content to members through that group. So you want to become a member of that. Any other words on the group that I'm missing?
I mean, look, Reach is the voice of advocacy for the lead gen world right now. If you are involved in lead gen, either as a buyer or a seller, you've got to be checking out this organization, looking at the standards, considering complying with the standards, make yourself a good actor, join an ecosystem full of other good actors, and help plan for the future. That is what this organization is about. And it's a big tent organization. We are happy to have buyers, sellers, platforms, vendors, everybody in the ecosystem can join and be part of really something very unique, very cool, and hopefully the future of lead gen for all of us.
Awesome. So definitely go check out the website to find out more about that. Very last plug, and then we'll get going, is contact.io. Contact.io is in August. If you're generating inbound calls, buying calls, making outbound calls for sales purposes, contact.io is the show to go to. Eric is going to be on the main stage talking about a lot of different things as well. So it's going to be really, really important to be there. But you're also going to get great outbound contact strategies. You're going to meet with partners that are driving inbound calls across multiple industries. And if you didn't notice, there's a $200 off code that's going across the board there or across the screen that you can grab. And there's a price increase in a couple weeks. I think it's actually not this Friday, but the following Friday. So use that code now before that price increase so you get the lowest price possible. And that is it as far as promotions. And don't forget, you can go back after this and go back, after this is recorded, and you can go back to this and grab this code, grab the website for Reach, grab tcpaworld.com. Hopefully you can remember that one. But that is it for all the promotions. So let's dive in here, Eric. We've got a lot going on. And I've got a huge list. We only have you for now 50 minutes. So we want to try to dive into this because your time is very, very valuable. So let's go. Let's talk about what's happening in TCPA. Obviously, it sounds to me that TCPA cases have been skyrocketing. So what's going on there?
Yeah, so it's insane. And one last thing for Contact.io, it's a great show. You guys should all be there. I'm going to be there. I'm looking forward to it. So TCPA cases, class litigation, last year, 2024, it was the highest volume of TCPA class actions in history. Okay, that's 2024, last year. This year to date, we have doubled the number of class action filings from last year. So last year was the top ever in history. This year, we've already doubled. Okay, we've gone parabolic. It's hockey stick growth. Okay, and not what we want to see hockey stick growth on litigation. So a lot of this is being driven by the time out of time limit text message cases. A lot of this is being driven by the revocation rule change. So if you are running an SMS strategy, you better make absolutely sure that you are texting within 8 a.m. to 8 p.m. or 9 p.m. depending on your jurisdiction. One, and two, if you're running any kind of campaign for anybody, you've got to make sure that you are honoring those revocations. And the rules have changed. Something we're going to talk about. The rules have changed. You got to be compliant because those are the two things, right? Like if you look, and I don't read every single complaint, but I look at every single complaint. And I got to tell you, like those are the two big changes that we're seeing. And again, it's spiking, guys. So TCPA compliance, I would say it's out of the gate, 2025, more important than ever before. And you've heard me tell you that multiple times, and it just keeps getting more. I mean, dangerous is not even the right word. It's just the number of plaintiffs' lawyers bringing these cases is increasing. The volume is increasing. So your odds of being trapped in one or more than one of these cases, very, very high. And of course, TCPA class litigation, for those of you that are not into TCPA world, remember it's $500 per call, 4-year statutory look back. You're talking about billions of dollars in potential damages in really all of these cases. And there is the potential for personal liability. Okay, so even if you've got a corporate entity and you think, oh, I can't be sued because my entity will be sued, I'll just shut it down and start a new one. That's not how it works in TCPA world, guys. You can be personally named if you're the CEO, personally named if you're in charge of the call center, if you're setting up the campaigns, if you run the BPO, like wherever you sit, you can be personally sued. So you got to comply with the statute. And again, through the roof, guys, through the roof.
So, and I don't know if it's just me, if it's me, but there might be some connection issues on my side as well here. So if I ask you to repeat something, I apologize.
Oh yeah, sure.
I just want to make sure everyone gets everything. What are sort of the common mistakes you're seeing when, consent is being collecting that's leading to these lawsuits?
Yeah. So again, there's a lot of different issues here. I would say, the most prevalent cases that we're seeing out there, again, revocation cases, people not honoring the DNC requests, not doing it timely, the out of limit text message cases, like I told you, you're sending the message at 7:58 a.m. instead of at 8 a.m., right? That's trapping just a ton of people. But more broadly, right, your wrong number cases, wrong number pre-recorded call cases are a huge driver of litigation. You've got to be using the reassigned number database if you're calling aged leads, right? There's always some risk if you're buying a lead, because somebody could type in a fat finger phone number. Understand, like, you're liable for that. If a consumer puts in the wrong phone number, you're liable for that. But that is in an isolated case, that's not that big of a deal. But if you're doing that repeatedly, you're not using the reassigned number database, you don't have a good practice or policy around dealing with wrong numbers, you can get yourself just destroyed. So we're seeing a lot of that. And I mean, look, to be perfectly honest, the old school, it's the same case you've seen 1,000 times, which is the guy said, I didn't do it, right? Lead form gets filled out. Plaintiff says it wasn't me. And that is the classic TCPA case impacting the lead gen industry. It continues to be the classic TCPA case impacting the lead gen industry. Where there's evolution, where there's kind of new cases that we're seeing different strategies. You're seeing the caller ID litigation come out now, which is a totally new strategy for the plaintiff's bar, which is if you're not identifying yourself as a telemarketer on the branded caller ID solution, that is in and of itself a violation of the TCPA, right? So that's kind of a new angle that they're coming after you. And then there was one other big one that's coming out. It just slipped my mind. We'll come back to that. But
yeah,
a lot of different flavors that are out there. So you got to be careful.
Yeah, so that's why I was going to sort of ask you what those sort of tactics that you're seeing the plaintiffs starting to use. So obviously being aware of your calling hours, and then also that caller ID mention, and then calling bad number and service being the plaintiff attorneys use.
So yeah, we do have a little bit of a connectivity issue here, but yeah, so the plaintiff's attorneys, right? I mean, their strategy is it's gonna depend on the lawyer. Some of these guys, like Anthony Peronic, he loves to use the repeat litigators, right? The guys that have filed 1,000 cases, and he likes to use those guys because he figures, hey, they've done it before, and so he knows they're going to go all the way, right? But many of these guys will fill out forms, and you got to make sure you're using your litigator list to avoid these guys. They're very tricky. The B2B rules allow people to have their numbers listed as a business number publicly, right? And so you, as a company that's trying to do a B2B call, you think, oh, well, this is a business number, I'm going to call it. But guess what? It's a cell phone, right? It's on the DNC list. They also use it, they claim, and they probably do, as their residential number too, right? They talk to their kids on it, like my number, right? I talk to my kids on this number, my family, but it's also my business number, right? So in these instances, the courts say that is going to be a residential number. So that's like a really clear trap where you will literally see somebody put their phone number up as a business number. It's on Zoom Info, right? It is a business number, but it's also a residential line. It's also on the DNC. It's also a cell phone, right? And so these are things that you're seeing all the time. And again, you don't have to lay too big of a trap in the TCPA because there's going to be plenty of wrong number phone calls out there that are real wrong number phone calls, and you're going to be liable for that. There's going to be plenty of unfortunately non-reach members, third-party lead generators that still to this day, they'll buy data and have a bot fill out a form, right? And they'll sell it to you. So you got to watch out for that sort of thing. You got to know who your partners are, because I cannot tell you how many cases, I'm seeing still to this day. You would think that this would start to abate, but it's really not. Where, you buy a lead from an aggregator, the aggregator buys it from, maybe another aggregator, maybe a network, whoever. And there's, always some sub-affiliate downstream that has done something nasty, and maybe they're in Pakistan, maybe they're in wherever. And it's always the same story when it hits my desk. Oh, Eric, it was a test on some sub, and there was only, it only ran for 2 weeks. So what's the big deal? Well, the big deal is now you're in a class action and they're in the wind and you have no consent record. So good luck, right? I mean, that's a very tough case to defend. So again, these are just kind of the issues that you're seeing out there. These are all different kinds of strategies that, again, it's not even necessarily a strategy, but the places where the plaintiff's lawyers are looking to exploit you.
Yep. So Kurt had a question. He's seen DRTV spots with a QR code that launches consumer SMS applications with a pre-written text. He says it seems the perfect consent solution as the consumer has initiated the outreach to the seller. Do you have any thoughts on that tactic?
Yeah. So look, anytime that you can get a consumer to initiate the conversation, there's lots of tactics to do that. A QR code is just one of them. Anytime you can get a consumer to initiate the inbound call, that's great. It's fantastic. But from a consent perspective, it's not a silver bullet. And by that, I mean the inbound call itself is not actionable, but it's also not consent. Now, for DNC purposes, an inbound inquiry where the consumer actually stays on the line and talks to you and expresses interest, yes, that's going to be an inquiry. You're going to call that consumer back, even if they're on the DNC, manually for 90 days. But where consent comes in is where you're using regulated technology, right? You're using your AI outreach, you're using an auto dialer to make the outbound call, or a pre-recorded voice or an artificial voice. If you're using any of those kinds of technologies for an outreach, remember, you've got to have express written consent to do that. So if the consumer makes an inbound call to you, sure, you can talk to them all day long. And if you're a generator, you can talk to them and you can transfer them. Totally fine, totally clean, no problem. Where the issue comes in is if you want to call them back, right? Or if your lead buyer wants to call them back. Well, there's no consent to do that, right? And in the situation where it's a lead buyer, the lead buyer can't even call them back manually because that's not an inquiry made to them. So example, right? I am Bob's lead gen. I have a consumer initiate a call to me, Bob's lead gen. No problem. That's great. And Bob's lead gen could probably even call that consumer back manually after the consumer has said, I'm interested in home services, let's say, right? But when I sell that lead to George's window shop, George does not have an EBR, right? That inquiry came in to Bob. It did not come into George. So George cannot call that consumer back. Not only can they not call them back using regulated technology, if that consumer is on the DNC, they can't call them back even manually. So that's an issue, right? It's great that the call came in inbound. There's no consent required, but it's also not a consent event, meaning George gets nothing out of it unless he can close on that phone call. So now you need a different set of tactics once that consumer comes into your ecosystem to obtain the right level of consent.
And so what is that? And what is that, Eric? Like, what is that level? Like, what is that next step to get that consent? Either is it sending them a link? Is it on the phone? What is it?
Well, there's lots of ways to do it, right? And there's some new solutions out there. I know that Call Comply is one. There's a few, right, there's some vendors that are kind of specializing in taking inbound calls and converting them into a consent event. And I don't necessarily tell you to use any of them necessarily, but what you have to be able to do is get the consumer to engage with a form or something in writing. And you can have them download an app. You can have them go to a website. You can get them to agree to an informational text message. I've seen some like AI platforms now where the consumer is agreeing to communicate with the AI platform, even like a video format. I mean, you've seen some really interesting stuff that's coming out. So there's lots of ways to skin this. And I'm not here to kind of tell you have to do it one way or the other, but you do have to be very cautious, right? Because the inbound call does not give you the level of consent that you would want to be like, hey, I'm going to shoot you some marketing messages now that I've got you on the phone via text. Is that okay? That is still not okay because that communication is not in writing itself, right? It's very strange to think about. But even if the consumer says, yes, send me a marketing message real quick, you can't necessarily do that because that requires express written consent. And the consumer saying yes is not express written consent. So you have to convert it into a transactional message first. And then from a transactional message, you have to take the leap into making a consent that is a marketing consent. So there's a little bit of detail there. And you can tell I'm kind of hiding the secret sauce. But it can be done, and you probably want a lawyer to help you or one of these vendor solutions.
Yeah. Now, let's just dive into revocation then, because I feel like we're kind of going down that path here now with consent. Tell me what's going on. Tell me what's happening with consumers revoking consent and how that affects cross-channel, cross-communication opportunities.
Right. So a couple of pieces to it. First, I'll give you the easy one, right? Before you had 30 business days. Now you have 10, sorry, you had 30 days, calendar days. Now you have 10 business days. The FCC was going to change the rule to 24 hours. Reach got involved, told the FCC, hey, look, that is crazy. Businesses cannot live with a 24-hour revocation rule. Offered 10 business days. Guess what? The commission said, we agree with Reach. We'll give you 10 business days. Good news. So 10 business days. So it's down from 30, but it's still 10 business days. That's not that bad. Two, though, and this is the big change. This went into effect already, right? April 11th. So this is in effect right now, right? Is you have to honor free form text message revocation. And companies are having a tough time with this. And this is driving litigation, right? I think the most classic example I've seen so far is the consumer said cease and desist communication via text, right? Look, I mean, that's pretty clear. If you're reading this, like, you know what that means. But obviously they did it because they're assuming that your message program, right, your SMS program can't pick that up. And I'm going to tell you, the FCC and the courts, they don't care. All right. You do not get to have a defense now in a TCPA case that, oh, well, my platform only honors the word stop, or it only honors stop, cancel, unsubscribe, and quit. Right. Nope. I'm sorry, guys. Like, you've got to be in a position to be able to honor any kind of a free form revocation that's clear. Now, the courts are, I think, going to be pretty fair, right? And so if the person is saying something, where they're plainly trying to trick you, and they used to do these old opt-out evader cases, it sure would be wonderful if you could consider sometime in the not so distant future that you would limit the number of messages, or perhaps just allow them to no longer continue, right? And it's like, come on, what the hell is that, right? These very fuzzy, maybe it's revocation, maybe it's not. So I think the courts are going to be siding with businesses with that crap. That's the good news. But again, like, cease and desist communication, like, we've got to be able to honor that. And even if it's still them trying to trick you, it's going to work, right? Because again, the test is just going to be, as a reasonable person reading it, like, do you know that this person wants you to stop communicating? And if so, you got to be able to do it. And again, if you start looking at the SMS cases, the class action complaints that are being filed, like, this is what people are looking for. And of course, like, the basic stuff. I mean, there are still cases, I don't know how or why, I guess it's just like a bug, perfect stop, and the messages just keep coming, right? And that can happen because maybe there's multiple leads, multiple records. It can happen, there's multiple accounts. Like, there's lots of places where that happens. But again, the courts have been very unforgiving. So you've got to make sure that you are honoring that stop, right, at the consumer level, right? Not at the phone number level even necessarily, but I mean, sure, at the phone number level if you have to, but not at the account level, not at any other kind of, if you're a lead gen and you're sending a message from a single short code on behalf of multiple potential buyers or multiple verticals, you get one stop on that short code, you better be stopping. You just better be stopping. I don't care that they consented 4 different times for 4 different verticals and you're using the same short code for each one. Nope, you got to stop because that's going to get you sued. So these are just some small examples I'm telling you, though. The revocation piece, that is the big driver. And I've got major clients, like Fortune 100s, like huge entities. They're like, man, this is tough, right? How do when I'm receiving, 500,000 inbound text messages a month, right, or more, how do I determine which ones of these are stops and which ones are not stops? And again, there's vendor solutions out there. I know Drips has one. I think it's called DQ that they've brought to the market. So, I mean, there are vendor solutions, but like, really everyone just needs to be asking themselves now, like, what is my strategy to comply with this?
Yeah. So now, am I wrong or did it not go into place where the revocation also applied to multiple communication streams?
Yes. So that was the other big thing. The FCC's rule originally was supposed to go into effect again this April. And the rule was essentially any stop, any cancel was going to remove the ability across channels for all calls or messages that have the same level of consent, even if they're for a completely different purpose. And this was just going to be just a neutron bomb, right?
Right.
I mean, if you're Wells Fargo and you send a notification that somebody's logged into an account on a different device, and they say stop to that, Now you've just lost the ability to send them updates about their account. You've lost the ability to give them a fraud alert. You've lost the ability to send them marketing. Like, you've just lost all right to communicate, and not just for the banking product. If they've got, a student loan, you can't communicate them with that anymore. It's crazy. Like, enterprise was just going to get nuked by this. And so the CBA, that's the Consumer Bankers Association, came forward along with the MBA and a few other trade organizations. And they said, hey, look, FCC, this is going to be really, really bad, particularly for the banking, but not just the banks. I mean, pharmacies, you name a retailer and they're going to have multiple touch points with you. You name an insurance company, they're going to have multiple touch points with you, right? So this was going to destroy enterprise. And it was going to be very, very bad for the lead gens too. But what happened was the new administration came in, which is good. But what's fascinating is they had a lot of options that they could have done with this ruling. They could have torched the whole thing. They could have stopped the whole thing. They could have stayed the whole thing. Mm-hmm. And instead, as you heard me tell you, they let 75% of it go into effect, as we just discussed. The 25%, though, that was the worst, right? This scope rule is nuts. It's terrible. It's insane. The FCC could have gotten rid of it completely, but they didn't. But what they did say is you get 1 year. All right. So the rule is still going to in effect, but not until April 2026 now. And we're going to start talking about this a lot more come like August, September. But I mean, as I just told you, as you just previewed, right? The issue is now, if you're communicating, and again, most of these folks are lead generators, we're communicating for marketing purposes. That consumer says stop. You've got to stop across all channels for all purposes. And you've got to make sure that you're communicating that if you're a lead gen, or let's say you're a BPO, step outside of pure lead gen and talk about, okay, we've got an ingested lead. Now we're going to work a lead, right? And the enterprise or a business calls up a BPO and gives that BPO, the right to make some phone calls, or they're using call center, or maybe they're using other lead gen animals, whatever it is, whatever your flow is. Anytime that consumer says stop, you've got to be able to ingest that, report it back, and that enterprise or that business needs to be able to, again, isolate all campaigns across all channels for that same level of consent. If it's a servicing call, everything gets nuked. If it's a marketing call, all your marketing initiatives get nuked. So it's a huge deal, but you got till April now.
Okay, so we got till April. I suspect groups like Reach and others will, start to communicate and try to, essentially push against this.
Well, it's going to be a challenge to push against it, but we will. I mean, look, without question, we'll be in there. CBA will be in there. We're going to do our best. The issue, and it kind of ties up to, I think, what was going to be your next topic, which is the FCC's kind of melted down right now.
Yeah.
It's a fascinating thing that's happened, right? Because the previous administration did all this stuff. The new administration came in, and I think there was high hopes that they were going to undo some of it. Mm-hmm. And so far they haven't. They did stay. They stayed 1-to-1, which we appreciated. The 11th Circuit finally killed it, which is great, right? That's helpful. But the FCC didn't do that much on that. On revocation, the FCC could have done a whole bunch more. They didn't, right? They just kind of stayed a piece of it, and they let the rest go forward. So now, though, we've got until April. So we think, okay, that's fine. Maybe we can get the FCC to do something. Maybe. But here's the issue. Right now, we're down to 2 commissioners at the FCC. There's 5 usually. We're down to 2, right? So the chairwoman, Rosenworcel, left, that's customary, right? Anytime a new administration comes in, the old chairwoman or chairman leaves. Fine. So we're down to 4, right? 2 Dems and 2 Republicans. And then Democrat Starks, he stepped down, which, again, not too surprising, but a bit of a surprise. All right. So now we're down to 3, and we had 2 Republicans and 1 Democrat, which, again, is fine, right? Because 3 is a quorum, and the commission can still act. And maybe that's not even that bad, because now it's Republican, majority. So maybe that's not so bad. Then Commissioner Symington, one of the 2 Republicans, steps down, which was very surprising. I don't know anyone that expected that to happen. It kind of made news when it happened, because it was like, whoa, where's this coming from? And he stepped down quick. He gave notice, and within 8 days, he was gone. So now, right now, today, we're down to 1 Republican, that's the chairman, Carr, and we're down to 1 Democrat, Anna Gomez, right? So that's it. We only have 2 commissioners at the FCC. Well, what does that mean? What it means is they cannot act, right? They don't have a quorum. There's nothing they can do. So right now, all FCC activity is essentially ground to a halt, unless it's something customary that like the Bureau can do. But any change that we're going to be looking to an existing rule under the TCPA, nope, that's got to come from the commissioners. So for now, there is nothing, literally nothing that can be done on any of the current rules. Nothing. Now, Trump did appoint or nominate, I should say, Olivia Trusty, and she, as her name implies, is trusty. And people like her. She was a staffer in the Senate. I think I reported this previously, right? She worked actually for Senator John Thune, who's now the current majority lead in the Senate, also the guy behind the Trace Act. Olivia Trusty has a good background in telecommunications and in policy law around telecommunications. So she's a very good fit for the commission. Everyone I've talked to thinks she's a shoo-in. She's not a political character. She's not one of these, off-the-wall knuckleheads. Like she's a qualified person. She's a qualified person. So everyone I've talked to thinks she's going to go sailing through. But guess what? She can't go sailing through until there's actually a hearing in the Senate. And as you all know, the Senate is tied up with a bunch of stuff, not the least of which being the big, beautiful bill that seemed like it was going to go railroading through. And now all of a sudden, like, I don't know. So until the Senate can actually pay attention to Trustee, which all indication now is that it's going to happen after the July 4 break. So we're not going to see anything till September, maybe October, right? Until she gets in there, there's nothing the commission can do. So in all likelihood, we're looking at 4 or 5 months where the commission's not doing anything. And that means all of our advocacy is just pissing in the wind, man. You can't do anything. So, when she's in, say, November, is it possible between November and April we get some change? Yes, that is possible. Is it likely? I don't know. It depends, right? It just depends when we start getting in there and talking to them where their priorities are, because you can imagine after 5 months, there's going to be a big backlog of other things that they're going to be very much paying attention to. And as you know, you heard all the things that Trump has said so far about everything in the world. He has not talked about the TCPA or robocalls at all, right? So yeah, this is not going to be a priority, but that doesn't mean we can't affect change, but it's not going to be a priority.
Got it. Understood. So, waiting until that time comes when she gets appointed, are there anything other sort of signals that we should be watching for with the FCC to anticipate, their future direction or any policy pivots? Or is it really just relying on essentially getting staffed up?
Yeah, look, we should always be paying attention to the commission. They will be back. It's just a matter of when. There's an open meeting that they have every month. We always pay attention to the agenda items. We always pay attention to what's happening out there. But again, that from a telecom perspective, they're focused on lots of other things. The commission's got lots and lots of obligations, right? From a text message phone call perspective, what they're mostly focused on right now, and this is the big reach initiative ties into this, is carrier call blocking and the anti-spoofing, shake and stir rules. And there was two 8th reports and orders, 2 different dockets. Both of them have an 8th report and order that just came out within like 3 months of each other, which is really very fascinating. And so they're really kind of focused on, for instance, on the one hand, shake and stir, saying that third parties can't be utilized to determine what level of attestation is going to be attached to a communication. So that whole thing is kind of unwinding right now. In fact, that goes into effect June 30. So that's happening right now in real time. And a lot of providers are struggling to get their mitigation database, robocall mitigation database filings updated as are required by the new rule. So a lot of stuff going on there. And then on the other hand, right, there's a new requirement for redress and SIP notifications when your call is being blocked. That's going to go into effect soon. The carriers have to honor. So there's a bunch of pieces on both sides of that. But again, nothing from like a TCPA, pure TCPA perspective. It's mostly like robocall mitigation more broadly. And of course, Reach is out there right now with a major petition. And we just met with the commission. We met with the chairman's office like 45 days ago. And we received very positive signals, very positive on the petition, which is to ask the commission to ban the carriers from blocking consented calls and from labeling consented calls, right? And as you guys have all experienced, you're out there trying to send messages that the consumer they've asked for, they raise their hand, they're like, hey, yeah, I want to hear about this. Please communicate with me. And the carriers are blocking these calls and they're labeling you a scam or even as spam, or spam is not as bad as scam. They're calling you a scam, right? It's wild. It's just wild stuff. None of that should be taking place We're asking the commission to stop it. The FCC's chairman's office has indicated to us that they think that we're right? That, yeah, no, the carriers should not be using content as a basis to block calls. They shouldn't be using viewpoint. There's a gap between unwanted calls and unconsented calls. They're two different things, right? And so the carriers need to be really paying attention to what is illegal as opposed to what they objective or subjectively have decided consumers aren't going to want. And all of these issues right now are in front of the commission, but again, they can't act. So it's kind of like we're all just kind of sitting on our hands for a little while until they get back. But you know who's not sitting on their hands is the states, right? So as the federal government becomes kind of paralyzed, at least at the FCC, other parts of the government are doing fine, but the FCC is paralyzed, just absolutely paralyzed right now. The states, there is now this thing called the 51 state robocall mitigation task force.
Okay, yeah.
I know there's only 50 states, right? But DC's got its own AG. And so there are the 51 states. So every single AG is working together. I'm going to tell you, in the history of the world, there's never been a 50.
Yeah, let's dive into this. I mean, how coordinated are they in compared to federal regulators, and what are they, what's going on here?
Pretty damn coordinated is the answer to that question. And so basically what's happening is the 51 state task forces all together. They're sharing notes. They're paying attention. They're looking at trends all across the country. They're paying attention to, hey, North Carolina just did X, Washington just did Y, Wisconsin just did Z. This is interesting. How can we coordinate? How can we share notes? How can we share briefing? How can we share resources, right? And mostly, how can we share intel about who's the good guys and who's the bad guys, which is why Reach, again, is trying to coordinate with these guys so that, hey, we're the good guys. Here we are, right? So many people want to keep their head down and hide. Well, you keep your head down and hide in this environment, they're assuming you're a target, right? I mean, this is one of these, like, they're at war. And either you're waving the white flag saying, hey, we're the good guys. Here we are. Let's talk. Or they think you're a bad guy and they're going to nuke you, right? And that's what they're trying to do. So this task force came out. It's really interesting because, again, primarily the task force is sharing information and the states are going after people at the individual level. So you're seeing a lot more state level activity, like just a ton of CIDs and a ton of DOJ filings and a ton of AG filings. Like there's just a ton, right? But what, to me, the task force, which is so interesting, is what they're doing is they're going after the carriers, right? Which, again, has a trickle effect on all of us. And so, like, Lingo is a huge carrier. There was 8 carriers that were warned by this 51 state task force. Can you imagine this? 51 state AGs who basically said, hey, knock it off. They warned Lingo. They warned 7 other carriers because they were carrying allegedly illegal robocalls on their network. Now, these robocalls, right, are being tagged by something called the ITG, as the Industry Traceback Group, right? They're getting intel. You guys all know how this works by now from companies like Umail with these honeypots. We're going to talk about honeypot here in a second, right? They've got hundreds of thousands of phone numbers that are not in use, right? I'm Umail. I own 200,000 phone numbers. I'm No More Robo. I own 200,000 phone numbers. And they just listen to all the calls that take place, and they listen to they use these AI agents, and they listen to all the voicemails and they summarize them, and they find calls that look like scams, look like spam, and they will report that to the Industry Traceback Group. That's a private consortium created under the Trace Act, and that group liaises with the FBI, with the DOJ, and with the 51 state task force, right? And so what the task force did was it looked at the carriers that had the most ITG tickets, which is where the Industry Traceback Group says, hey, you've originated traffic that we think is a scam. Obviously, the carrier's like, I'm just a carrier. I didn't put it on the network. It's not my call. I'm just carrying it. But again, the task force doesn't care. And so they warned all these guys, like, hey, look, you had more than 100 tickets in the course of the last 3 years. I'm going to tell you, everybody has, right? Because Umail's flagging, again, you got 200,000 phone numbers. You're flagging 500,000 calls a day, right? So everyone's going to get tagged, everyone. And so this is where the pressure's coming in, right? Is the task force now is threatening to sue the carriers. We saw with SmartBiz out in Florida, even intermediary carriers can get hit for tens of thousands, hundreds of thousands of dollars in penalties for carrying traffic, even if they had nothing to flip and do with it, right? So again, all this pressure is on the carriers. So what are they going to do? They're going to block more calls, right? And on the one hand, you can't blame them for it. On the other hand, it's a terrible thing for everybody, right? So just understand that heat is on the carriers. Separately, though, right? All those tickets, these guys at the task force, they're reviewing them, right? And they're seeing who is behind them, who is behind them, who is behind them. And then you're seeing the state level actions. And there was even recently a prosecution, right? Because not all of these things are civil. There was a criminal prosecution against a couple of guys that probably scumbags, probably, but they were selling limited benefit policies to people who had filled out lead forms seeking, full benefit and health insurance. But as the story goes, right, they were running the call center, they were buying leads from, in the healthcare vertical. Probably, I'm not going to lie to you, probably the fine print in these lead forms probably covered limited benefits policies, probably said, these guys can call, and these guys were probably on the marketing partners list. Like, I don't know that, but that seems to be what happened. And yet the guys that then made the outbound calls are essentially being prosecuted for fraud. Like, they're facing 600 years in prison. Like, I'm not making that up. That's literally 600 years in prison because they called leads that were looking for full benefit health insurance and they sold them limited benefit. Now, it's not quite that clean. I mean, like, they were saying some shit they shouldn't have said. They were suggesting that they work with Anthem when they didn't, stuff like that too. Like, they were definitely gilding the lily, but the core of what they did wrong was essentially selling a product that the consumer wasn't in the market for based upon the leads that they were buying. And I think that's a huge wake-up call for people because, with one-to-one going down, multi-vertical lead forms are right back in business, right, from a certain perspective. But just understand, if that consumer is being tricked, it's not just TCPA risk, it's fraud risk. And at least one AG in Pennsylvania is going after that. So something to keep in mind.
Okay, I don't want to get too far off the multi-state task force because I do have a couple questions there. But, Ron's question regarding on the same topic here, is there any talk of them taking personal liability at the carrier level?
Yeah, I mean, the same rules apply to the carriers from a personal liability standpoint. It's the same statute, right? So I cannot think off the top of my head of actually, no, yes, I can, Palumbo. So yes, short answer is yes, you can have personal liability even at the carrier level. And again, you can even have criminal liability at the carrier level. The guy Palumbo, he was being targeted criminally as well. Now, again, in that particular case, there was clear knowledge and imputed involvement in the robocall scam. They were scam calls, right? And the argument was that this guy was basically the only source for this particular scam, and so they thought he was in on it, and so they went after him personally, and they went after him criminally. But the precedent stands regardless, right? If you are the owner of a carrier and you are allowing bad traffic on your network, you could be sued personally as well.
Got it. Okay, back to the task force. Are they specifically targeting any specific verticals, likely more aggressively than others, or?
Not that I have seen. Now, historically, EDU was right in the crosshairs, and the old school FTC, I think, was really kind of to home repair. Was kind of like they were like laser focused on solar. But the new task force, I have not seen a critical mass anywhere. Now, look, auto warranty is always something that people are looking at, right? But beyond that, I can't think of anything. It seems to be pretty vertical agnostic.
Yeah, I was just curious. Also, if there's this coalition of all these AGs, would you suspect? Because at the moment, states have a lot of different rules. They're not all the same, right? Which leads a lot of companies to have state by state compliance strategies. Is this a good thing that they're maybe coming together? There might be some consolidation of rules and regulations as well.
It would be great if that's what is going to come out of this.
Yeah.
I'm not seeing any indication that that's what's going to come out of this. So far, what's come out of this is they work together. They share notes on who is basically violating the federal statute, right?
Okay.
And then
they can just go after them.
Then they'll just use the state corollary, whatever it is, and just tag that in, right? So if you get sued in Wisconsin, you can get sued under the TCPA and under the Wisconsin Consumer Rights Act, right? If you get sued in Texas, you're going to get sued under the TCPA and the Texas Business Professions Code, right? And so that's just what they're doing.
Got it. Okay, we've got 15 minutes. We've got a couple other topics. We can talk about delete. We can talk about record retention. What I should have had a wheel where we just spun the wheel on the topic. But do we want to talk a little bit about delete?
Well, yeah. Well, so look, delete. We can put that in the FCC melted down bucket because delete, right, was a big initiative. We thought it was going to be a big initiative. They came out. They asked for, basically give me 10 regulations to get rid of for every one regulation we're going to make. Reach came out and we put, I think, like 28 different regs under the TCPA that we would like to see destroyed. And probably the most important one, there's so many that are like, potentially really big game changers. But this caller ID rule that I mentioned earlier is just a real problem, right? If you're making an outbound call, you have to have your name show up on this screen if it's for marketing purposes. And so few people are doing that. And every time you fail to do that, that's a violation of the law. So Reach asked for that one and like 26 other regulations to get thrown out. But again, with the commission essentially on ice, nothing can be done. Nothing can be done. Yeah.
With regards to deletion, is there such a thing as deleting data too soon? What retention period is considered legally safe?
Yeah, so we know now that the new TSR rules, and we're shifting over to the FTC, which is still functioning. Under the new TSR rules, you have to maintain your records for 5 years. And by your records, I mean all your outbound calling records, your outbound texting records, probably the content of your text. That's fuzzy, but probably the content of your text. Definitely the content of your pre-recorded calls, if you're making any pre-recorded calls. And if you're using AI, this becomes really fascinating, right? Because if you're using AI for outbound marketing purposes, it's pretty suggestive that you need to maintain a transcript of every single one of those outbound attempts, which no one's really doing. So pay attention. You also have to keep a record of all of your consents. Again, this is all for 5 years. And this is for any marketing calls that are either pre-recorded or text messages. So be very, very, very careful. That is not a brand new rule. That's been on the books now for about a year, but still people are struggling with that. There was supposed to be another new record keeping change with one-to-one, but sorry, I cut you off.
No, I cut out. Go ahead, finish that.
I was going to say there was supposed to be a new set of record keeping rules around taking possession of a third-party lead before you made an outbound call. That portion of the FCC's ruling is also dead following the 11th Circuit Court of Appeals ruling. However, I'm going to tell you, as a class action litigator that defends people that buy leads all the time, it is really, really helpful when you have possession of the lead form. And I don't just mean like the token. I mean like the lead form itself before you make the outbound call, because otherwise you're sending subpoenas to 500 lead providers that gave you leads over the last 4 years. And, when these guys don't show up and don't provide you the consent record, it can be a real problem for you in the defense. So even though technically you're not required under the law to do that, just understand the burden of proof is still on you.
Got it. I'm trying to think here. So I do want to get to some of your questions here in the group chat, folks. So feel free to type those in. Let's start off with Melody here. Eric, she wants your prediction. So do you think the ACA advocating for reinstating the EBR exemption for debt collection calls and other alignment between FDCPA and Reg F with TCPA? So I'm going to show this to you. I'm going to put it on the screen so it comes out so you can read it for yourself if that didn't make sense.
Yeah, I mean, so the CFPB recently put out regs that suggest that text messages are permissible. There's some like third-party disclosure rules that you got to keep in mind. And there's some other kind of messaging allocations that the CFPB suggested that seem to fly in the face of some of what the FCC has done. And that's kind of what she's driving at. Do we think that ACA will be able to get some good carve outs and have those two bodies of law align? Actually, I do think so. ACA has been a proven, they're kind of like Reach. Like they have proven to be able to get stuff done. They're very smart. They're very sharp. Their lawyers are sharp. And with this new administration, I think we'll see some much needed changes that are going to help the collection space. But again, not right now, right? Nothing's happening. Not until 26. And again, where is that going to fall? And again, in a weird way, now we're competing with ACA, right? Reach and ACA are on the same team, but there's only so many resources at the commission. And so if ACA is asking for something that's very common sense and Reach is asking for something that's very common sense, we might get both over time, but one's going to come first and one's going to come second, right? So, but the short answer is I think there is a real opportunity for that. I think that's a really good question.
Great. Listen, we don't have much left time here, so we're going to be wrapping it up here. But I want to give Eric the last chance. Is there anything that we sort of missed that you wanted to touch on before we go for the last 5 minutes here? Or I know we kind of bounced around and hit a bunch of different things. We didn't really talk about the SEPA laws change and California's law changes. Was there anything else beyond that?
Yeah, well, there is one thing I want to flag just because I think it's enormous, which is no more robo. Remember I mentioned earlier these guys with their honeypots, right?
Yep.
200,000 phone numbers, right? So no more robo just filed a suit last week against Synchrony Financial, seeking about $1 million in penalties for about 2,000 calls that hit their honeypot. So in isolation, like who cares? It's $1 million lawsuit, whatever. We see that 50 times a week. But again, time out. No More Robo has 200,000 phone numbers. As I told you a second ago, you're talking probably about 500,000 illegal calls get made to those phone numbers a day, right? So you multiply 500,000 times 500, you're talking about $2.5 billion in exposure every single day is being generated for calls to these phone numbers. So if No More Robo is given standing, and that's the question, does No More Robo, a company, they're not picking up the phone and talking, right?
What is No More Robo? Just has like you said, honeypot, just a bunch of dummy phone numbers, essentially.
Yes. And so backing up, so like No More Robo, Umail, these companies, what they do is they offer an app to consumers, right? And the app is designed to block unwanted and robocalls. Great. I have no problem with that. I think that's great. You want to sign up for that? That's fine. But in order to enhance their services, what these companies have done is they've got these huge honeypots of phone numbers. So they're tracking calling analytics. They're listening to messages. They're trying to figure out, hey, which phone numbers are scamming, right? To make their product as accurate as they can. And by the way, I respect that. I mean, I think this is great.
Yep.
But what they shouldn't be doing, in my opinion, is then using their honeypots, which again are just basically analytic tools. That's all they are. They're no one's picking up the phone and talking on these phone numbers. They're just monitoring the nation's calling patterns. Again, that's helpful. I'm glad that they're doing it. But for them to now turn around and say, okay, now I'm going to stand in the shoes of a plaintiff and pretend like I'm being hurt when this phone call is being made. Well, they're not being hurt. They're being helped, right? They're learning about the people that they're trying to block. They're not being hurt. They're in a weird way, they're grateful for the phone call, right? Yep. But now they're suing. Again, Synchrony was the first. And if this gets legs, I guarantee you guys, you're going to see No More Robo is going to be the #1 filer of TCPA cases in history. I mean, they're going to have
it's a huge business model. Yeah.
Oh, it's amazing. It's amazing. Yeah. These guys can make $1 million, for every company that they sue because the exposure could be enormous. It's wild. So anyway, that to me is a huge deal. And avoiding honeypots is always a priority. But now it's going to be like a super priority for business, and it's just something else to keep in mind. I know there's vendors that help you to do that. I know Ron Allen's shop, the contact center compliance, they're a Reach member. They help people to avoid honeypots. So that's all of a sudden it's priority.
So where's that case at now?
Just got filed. It's a brand new case.
Okay.
Just got filed. As soon as it came in, literally it came in on Thursday at 3:00 Pacific. I picked it up and I blogged it by 3:10 because it was just dude, this is crazy. And then Law 360, a couple other outlets picked it up after I blogged it because it's if this has legs, this is really going to change the world. I mean, it sounds kind of stupid, but if this has legs, No More Robo is suddenly one of the most valuable companies in the world from a book asset perspective.
Oh, yeah, for sure.
I mean, it's $2 billion a day, right? Yeah. Times 4 years. I mean, it's like a trillionaire of a company. It's insane. It's insane.
That is crazy. So we'll have to keep a close eye on that. Last question here, Neil. This here. Purchase offers are not solicitations. Does this hold true outside of real estate? with regards to buying versus selling.
Yeah, so this was a great new case came out. And again, look, this is a fairly gray area still. It's something that we'll probably talk about at the Law Conference of Champions here, which is you make an outbound call to a consumer and you're just trying to buy their house. Is that a solicitation, yes or no? Under the law, the answer is probably it is not, right? And the cleanest example is I'm like, hey, Mike, your house is awesome. Like, can I buy your house? And that's it. And I'm just really Eric Troutman wants to buy Mike's house. Totally legal, right? There's no question that that's legal. But of course, that's not what really happens, right? What really happens is I am a lead buyer or a lead seller. I call you saying, hey, Mike, are you in the market? Okay, great. Because if you are, I'm going to connect you with so-and-so and I'm going to get paid, right? So essentially, I'm getting paid for making that phone call, even though ultimately I'm not offering to have you buy or sell anything, or sorry, buy or rent something. I'm trying to see if you want to sell something. So the courts struggle with that because this intermediary guy is getting paid for the outbound call. They don't like that. That feels like a solicitation. But in a new case that just came out a couple of weeks ago, the court, I think, correctly said, look, the distinction is simple. It doesn't matter if I'm going to profit as the caller. It doesn't matter if the guy buying the house is going to profit because he's going to get it under market. That doesn't matter. What matters is Mike going to be engaging in buying activity, in which case it's a solicitation, or is he being asked to engage in selling activity, in which case it is not a solicitation? So that's a great ruling. Now, it was at a district court level, but I love how black and white it is, right? If you're asking the consumer to engage in a buying activity, it's a solicitation. Selling activity, it is not. Great. Very black and white. Again, that's just one court, though, right? Other courts have and probably will continue to disagree. But the question is that only applicable to real estate? No, it is not, right? That line of reasoning applies to any vertical. It could be a car. It could be, I don't know, like whatever asset you're thinking about. If you're offering to buy versus offering to sell, in this court's view, that's the distinction that matters.
Yep. Yeah, I was trying to think of some other, example. Oh, sorry to talk over you. I was trying to think of some examples of other selling opportunities, from a house, with a person like to sell their house, like to sell their car. I can't really think of a bunch of others, but that's really, really interesting. So we're going to leave you here because I respect Eric and his time. And so I want you guys to know that I'm going to leave you with, if you want more information, we flew through a bunch of stuff here. You really need to get to Law Conference of Champions if you want to have a fully in-depth conversation about all these different things that are taking place. This is only just scratches the surface. So go to Law Conference of Champions, the website. If you can't find it there, TCPA World's got a bunch of mentions of it. Troutman and Mean's got a bunch of stuff on there. So check that out. And hopefully we'll also see you at contact.io, which Eric and his team will be there as well. But first on the calendar is Law Conference of Champions. So be sure to check that out if you're really interested in this information before it sells out. It's Eric's show and it will sell out. So otherwise, check out Reach, check out Contact, check out Law Conference of Champions, and we'll leave it at that. Eric, I appreciate you as always, giving us your valuable time to answer some of these questions and just provide a little bit of clarity. You always do a really, really good job at articulating some of this crazy stuff that's sometimes hard to articulate. So I appreciate that.
Always here to help, man. I love you guys. Thanks so much, Mike. I really appreciate it.
All right. We'll talk to y'all later. Enjoy the rest of your week.